Good morning to all of you. Welcome to Legal Matters by Sai Babu Sangara. In this video, we are going to discuss a Supreme Court decision regarding the multiplier theory. You all know that the multiplier theory will be applied on the death of a person. So the age he is expected to be alive, suppose in case he is alive, then the emoluments he takes, all these things will be taken into consideration, and the Motor Vehicles Crimes Tribunal, they will award the compensation by using the multiplier theory. But what happens in case of bachelors? This is more important. While dealing with the case of Giasiram, Giasiram, Giasiram and another versus ICICILombard General Insurance Company Limited and others in civil appeal number 7055 by 2022, dated 29th September 2022, two judges bench, Honorable Justice S. Ravindra Bhatt and Justice J. Sudhanshu Durya. They clearly held that age of the deceased bachelor and not age of the dependents has to be taken as the basis for the multiplier theory. Right? It is very clearly stated. Now, we'll go to the facts of the case. So actually, this is a case for claim of compensation for a person, for a bachelor who is involved in a motorcycle accident. Right? So in 2017 or so, the deceased bachelor was going on a motorcycle and he was hit by the opposite coming vehicle, due to which he received fatal injuries. No doubt, he is the son of the so-called appellant, that is Giasiram, and actually she got him admitted in a hospital, but actually due to the fatal injuries, he succumbed to the injuries. Yes, succumbed on the account of the accident, he died. So they claimed the motor vehicle compensation as the mother is the dependent on the bachelor son. Now, the tribunal calculated the percentage of the multiplier at 18%, because suppose if the deceased person who is aged about 21 years at the particular point of time, his lifespan is around 80 years. So actually they stated that he was earning about 10,000 or so, but it was calculated 3,063 to 3,683. Ultimately, compensation of certain amount was awarded by the tribunal. Right. Here the point is, the ICICILombard company, they are not satisfied. Therefore, they went in appeal to the High Court. The High Court, yes, has reduced the multiplier by 9 because they have calculated the age of this particular woman. She is aged about 40 years or so. So she will die at the age of 80 or 90. So therefore, they have reduced the multiplier to 9. Once again, this woman not satisfied with the High Court judgment. She approached the final authority, that is the top court or Supreme Court of India. Now the matter has come before the two judges bench, Ravindra Bhatt and Sudhanshu Durya. Right. Now, please remember, Honorable Supreme Court based on or held that the age of the deceased, it has to be taken into account, because on whose behalf we are giving the compensation only for the deceased person. On his behalf, the dependent will take, but he should not take the age of the dependent into consideration. So please remember, the age of the bachelor has to be taken into consideration. Therefore, the tribunal, MV Claims Tribunal, that is the original tribunal, which fixed the multiplier at 18, is 100% correct. Because, no doubt, she was working with now this woman, as she is working with some informal sector, and now her pay is fixed around 4,107, excluding the cut-off salary and other things. they have clearly stated that multiplier of 18 should be added. So 40% of the compensation should be restored back to her. This is the very good judgment on behalf of, it will be useful for all persons who are involved in the accident cases. Here the important point you have to know, I will tell in Telugu also. Important point you have to know is the age of the deceased has to be calculated for the multiplier theory, not the age of the dependent mother. ఈ కేసులో ముఖ్యంగా సుప్రీంకోర్టు చెప్పింది ఏంటంటే, సహజంగా ఒక మనిషి చనిపోయినప్పుడు అతని యొక్క ఏజ్ 20 ఏళ్ళప్పుడు చచ్చిపోయాడు అనుకోండి, అతను ఎంతకాలం అవుతాడు, 80 ఏళ్ళు వేసుకోండి, వాడి శాలరీ మధ్యలో ఇంక్రిమెంట్స్ ఎంత అవుతాయి, ఆ కాంపెన్సేషను మదర్కి ఇవ్వాలి. కానీ హైకోర్టు ఏం చేసింది, ఆడు చచ్చిపోయాడు కదా, ఆమె ఎంతకాలం బతుకుద్ది, ఈ పేరు దట్ మదర్ ఎంతకాలం ఉంటుంది, ఆవిడకి అప్పుడే 40 ఉంది అనుకోండి, 60 years, మల్టిప్లయర్ 9కి తగ్గిపోయింది. కాబట్టి ఇది కరెక్ట్ కాదు. సో మల్టిప్లయర్ది చనిపోయిన అతనికే వర్తించాలి. అతను 80 ఏళ్ళు బతికుంటే ఎంత కాంపెన్సేషన్ వస్తుంది. సో దిస్ ఈజ్ మోర్ ఇంపార్టెంట్. సో you can cite this case law as and when required. So very good judgment. Please read the judgment and enrich your legal knowledge. Thank you.